the trial of Karen Reed for the death of her boyfriend, John O'Keefe, is underway.
There are 17 jurors, and they're coming and going with a police escort.
I've seen a lot of things. I've never seen anything like this. This case never ceases to amaze me.
The first week of testimony has come to an end.
It's a spectacle, that's for sure.
We really heard the defense highlight some of the discrepancies between what was documented and what first responders said they remembered.
There are a lot of issues in this case.
Proctor was improperly searching Karen Reed's cell phone for nude photos.
The fact that the investigation wasn't thorough provides a big wrinkle in the prosecution's case.
They're supposed to be creating this reasonable doubt, and they're doing exactly that.
Everybody wants to know, us included, why he wouldn't go inside that home on the night that the body was discovered.
There are more people here at the beginning of this than at the beginning of Johnny Depp's trial.
It's always the theories or stories that each side will put forth, right, for a jury to listen to and decide which one is more believable.
We asked Karen Reed about that alleged confession. Karen, did you ever say I hit him?
I did not.
The FBI is investigating an investigation of a murder. That never, ever happens.
Karen Reed was drunk and angry and hit and killed John O'Keefe when she gunned it in the snowstorm.
We're looking at arm injuries with scratches. We're not looking at tire tracks.
I did not kill John O'Keefe. I've never harmed a hair on John O'Keefe's head.
Defense attorneys learn in school, first class, the most important thing you can do is identify and select stupid juries.
We're not concerned about any of the witnesses. None of the Commonwealth's witnesses are concerning us.
Karen Reed is facing up to life in prison.
I just hope justice is served for either one, whatever it is, you know.
The fate of her life is not in her hands anymore. It's not in the hands of her attorneys. It's not in the hands of the prosecutor. It's in the hands of the jury now.
Free Karen Reed! Free Karen Reed! Free Karen Reed! Free Karen Reed! Free Karen Reed!
The Karen Reed saga is far from over, and on August 9th, a hearing was held for Judge Beverly Cannoni to listen to the arguments from the attorneys on both sides about the motion for dismissal. I mentioned in a previous episode that there had been multiple jurors who have reached out to the attorneys to say that they unanimously agreed to acquit Karen Reed of count 1, which is the second-degree murder charge, and count 3, which was leaving the scene. They said that the charge that they were hung up on was the second count, which was the manslaughter charge with the lesser includeds as options. The jurors who reached out said that there was confusion about how to communicate to the judge that they had reached a decision. When their note indicated that they were unable to reach a unanimous verdict, they were expecting some further instructions about where to go from here, but instead, a mistrial was declared and the jurors were dismissed. Criminal defense attorney Martin Weinberg joined Karen's defense team for the motion to dismiss. Weinberg is a Harvard Law graduate with more than 4 decades of experience as a trial and appellate attorney. He's also an educator and a leader in the legal profession, selected for inclusion in the best lawyers for 31 consecutive years, literally every year since 1988. He's also earned the Martindale-Hubbell AV Preeminent Judicial Award, which is the highest level of peer rating available. This means that his peers have ranked Weinberg at the highest level of professional excellence for his legal knowledge, communication skills, and ethical standards. Weinberg was a phenomenal choice to argue the defense's motion for dismissal. And that's not taking anything away from the other attorneys. Alan Jackson is charismatic and knows how to play to a jury. David Yannetti is likable and relatable. And Elizabeth Little is factual and concise. But this argument isn't for a jury. It's for Judge Cannoni. And choosing an attorney who is so knowledgeable in the law, so experienced, and well-respected was a smart decision and the best chance that they may have at the judge granting their motion. The judge allows the defense to argue their motions. Then the prosecution gets a chance to give their arguments, and then the defense is given a rebuttal. So first up is Weinberg. He begins by saying that there are 2 central issues raised by the motion to dismiss. The first, he says, is the strong and uncontradicted evidence that the jury reached a unanimous decision on 2 of the 3 counts, even if it wasn't formalized into a vote or into a polling announcement to the court. He says that the legal issue here is whether or not Karen Reed can be re-prosecuted for the same offense by the same prosecutor that failed to prove her guilt to even one, much less 12 jurors in a trial. He goes on to say that this is now a matter of how to transform the representations that the jurors made in the attorney affidavits into hard proof that convinces the court and even Lally and the district attorney's office that the jury, the same jury that the judge referred to as extraordinary, reached a decision that was unanimous and final. And there are jurors who are willing to appear before the court and inform them of that. The second issue, he says, centers on the double jeopardy clause that deters and prohibits a second trial if the jury reached a unanimous decision in the first one. Weinberg says that we have evidence now, evidence that the judge, the prosecution, and the defense didn't have at the time, evidence that the jury was not at an impasse, at least on counts 1 and 3. In the prosecution's response to the motion for dismissal, Lally said that the note that the jury sent was very clear that the jury was hung up on all 3 counts. Weinberg explains it's not that simple.
The note they wrote to Your Honor after the Toohey charge on July 1 was not unambiguous, as Mr. Lally wrote in his pleading. It was ambiguous. It was subject to 2 constructions. One, that their impasse covered all 3 counts, and therefore would lead ineluctably to a mistrial declaration, or 2, that the impasse was on 1 count with multiple lesser included charges, but did not encompass counts 1 and 3. Your Honor didn't know what was in the jury's mind, what was in their mind when they authored a note to the court. Neither did counsel.
Weinberg says that the issue now becomes double jeopardy. He explains that double jeopardy is a historic and important clause enacted by founding fathers to give them some protection against simply choosing to mistrial prosecutions that weren't going well. The founding fathers wanted to protect citizens from having to face re-prosecution, from having to go through proving to a second jury that they weren't guilty after having already proven it to the first jury. He says the real issue here is legally what to do now that the jurors are declaring to the court that they believed they reached a verdict of not guilty.
What can we do on August 8th, if I've got the date correct? 6 weeks after the July 1 trial that Your Honor presided over, a lengthy trial with an exceptional jury. And I contend, Judge, that we can't just accept a fiction that the jury was at an impasse on all 3 counts when 4 jurors are saying to you through counsel they were not, and a 5th juror is saying to counsel indirectly they were not. We have to embrace the fact that these are now facts. Yes, they come after the end of the trial, but it doesn't mean that there's not some procedural pathway to integrate those facts into Your Honor's decision-making.
Weinberg arguing that we cannot just accept a fiction that the jury was at an impasse on all 3 counts when we are hearing directly from jurors that they were not. That is a strong and persuasive argument. And here's the thing. The defense isn't asking here for the judge to just take the affidavits of the jurors as evidence that she needs to throw the case out. They're arguing for the opportunity to have a procedural pathway to integrate these facts into the judge's decision-making. In other words, take these new facts that we've learned since the end of trial and give the defense the opportunity to turn those facts into hard evidence. Bring the jurors in and confirm that they reached a unanimous decision on those 2 counts. Because if they did, then double jeopardy would apply. So not retrying those specific indictments would be the constitutional thing to do. Weinberg also points out that all of the jurors who have reached out to both the defense and the prosecution have independently corroborated each other's stories. And what's equally as important is that there are no jurors who have reached out to say that's not true.
But here what we know is that 4 jurors reached out to defense counsel. Jurors A, B, D, and E, I think is the way they've been described by Mr. Jackson, who received calls from 3 of the jurors, and Mr. Yannetti, who received a call from 1 juror and talked to somebody who himself or herself spoke to a 5th juror. We also have the corroboration not just internally, where these four jurors are essentially saying the same thing. We reached a decision. We didn't denounce it. Some said we felt bad about it. We didn't know what to do. But they're internally consistent and not self-contradictory. And that makes them more trustworthy. They corroborate each other. And I contend that the voicemail left on Mr. Lally phone, which he responsibly shared with counsel and shared with the court, essentially saying this is probably one of the four jurors, but we don't know for sure, says essentially the same thing. We reached a decision that Ms. Reed was not guilty. And murder, the most serious charge that can be brought, a charge that would imperil the rest of her life if there was a conviction.
Weinberg argues that these jurors sat through many weeks of testimony, and this was probably one of the monumental and central events of their lives. Not many people have the opportunity to serve their community the way that these jurors did. And after all of that, not one juror has called or emailed the defense counsel or the district attorney's office to say that they are having their decisions misrepresented by these juror affidavits. Weinberg says that we don't have certainty. We only have reasonable inferences from the absence of other declarations, and that inference is that Karen Reed was found unanimously not guilty on counts 1 and 3. So then we get to the legal argument. Now, Weinberg begins this by telling Judge Canoni, this situation is not crystal clear. It's not crystal clear whether or not double jeopardy prevents another trial. This is a unique situation. But, he says, it's clear that we are not bound by labels, meaning there are court decisions that state that what counts as an acquittal isn't controlled by the form of a judge's actions. Weinberg brings up a Supreme Judicial Court case where Justice Ginsburg, Justice Sotomayor, and Justice Kagan make a point that form is not to be exalted over substance. So what this means is that the form of how something was done is not more important than the substance of it. In this case, the jury not filling out the two verdicts that they were able to agree on and having the chance to read them on record, that is not as important as the fact that the substance of that decision is that they found Karen Reed not guilty of those two counts. The substance here is far more important because Karen's constitutional rights and her freedom are on the line, and that is what the justice system is in place to protect. Weinberg said that he's done this for 52 years, and in that time, he's used to the burden being on him as a defense attorney to have to try to lay out the law to overturn a conviction when he's going through the process of appellate courts after a jury has already convicted his client. Now, that's a heavy burden, and for good reason. If a jury finds a defendant guilty, of course it'll be a heavy burden to overturn that. But he says this is different. The burden on the defense counsel here is to show that there was a unanimous decision, which they're asking for the court to give them the opportunity to do that. But then, he says, the burden on the prosecution would be to prove why they should be allowed to prosecute this case again if there's evidence proving that there was already an acquittal. Weinberg then explains the importance of double jeopardy.
The Warren Court in the case of Green versus the United States, and it's in our reading, said, and it's important, that double jeopardy was designed to protect an individual from being subjected to the hazards of trial more than once. That the state, with all its power, should not subject a citizen to the ordeal of living in a, quote, continuing state of anxiety, as well as enhancing the possibility that even though innocent, he may be found guilty by a second jury.
Weinberg says, so now what do we do in a world where we have facts that we now know that we didn't know in July? He says this isn't completely novel territory, and he gives some examples of the court bringing jurors back in for other cases. One example he gives is the Boston Marathon bombing. It's been 11 years since the bombing, and the Federal Court of Appeals is still dealing with whether the punishment should be life or death. The court recently issued an opinion that was over 100 pages where the decision was made to bring back 2 jurors because there is a principal basis to question their impartiality. He also references the case against Alex Murdaugh, where there were allegations that the court clerk, Becky Hill, spoke to jurors and influenced them. The judge held a hearing where jurors were brought back in and were asked very specific questions in order for the judge to make a decision. In other words, Weinberg argues, judges who receive reliable evidence that there is some kind of issue that needs to be addressed are able to hold hearings that can be done anonymously, which is exactly what they're asking for. The court is legally prohibited from inquiring into the content of deliberations or their reasoning, and Weinberg explains that's not what this is.
We have hard evidence that they reached a decision. We're not asking to have any inquiry, whether by counsel or by the court, into the content of deliberations, into their reasoning, into all of those matters that are forever private. But here we're asking them no more than Your Honor could have asked by polling them, which is, did you reach a verdict on count 1? What was that verdict? What about count 2? No. What about count 3? Yes. So there is precedent, although slightly different. We contend no less important to Your Honor making a decision. If Your Honor is skeptical in any way of the attorney's declarations, if you cannot accept them because they're not the sworn affidavits of lawyers, of the jurors, we ask, authorize them to do what they haven't, which is to reinitiate a call to these 4 or 5 jurors, ask them whether they would read the lawyer's affidavits and affirm that they're accurate, or alternatively, authorize the lawyers to ask the jurors whether or not they would execute an affidavit. It could be 2 sentences. We reached a final decision unanimously to acquit Ms. Reed in counts 1 and 3.
This seems like such a simple request. Let the jury tell the court whether or not they reached a verdict, and what that verdict was. They aren't asking to get into specifics on the deliberations or why they voted a certain way, just whether or not they reached a unanimous decision. Then the court can make decisions based on the information that the jury gives them directly. Weinberg tells the judge that she has a lot of discretion in terms of how to get to the bottom line. And the bottom line here, he says, is what is the truth. He knows how important this is and says that the defense is willing to waive public trial, which isn't something the defense has wanted to do up to this point. The media involvement in this case has actually worked to benefit the defense in numerous ways, especially with garnering support for Karen Reed. But they are willing to waive their right to public trial and keep the hearing private and confidential so as not to risk the jurors' identities being exposed. And Weinberg tells Judge Canoni, you can do that in a number of ways. Court officers can meet the jurors anywhere that the judge decides. There are responsible lawyers and responsible prosecutors in this case that he says can handle this in a way that doesn't challenge the jurors' anonymity. They're asking that the judge not close the door to new evidence and adopt a fiction that the impasse was on all 3 counts. He even says that he believes that if they are able to prove that the jury was unanimous, that even the Norfolk County District Attorney's Office wouldn't want to move forward with charges.
I am hopeful that the prosecution would join with us in not seeking a new trial if they were convinced by these jurors under oath to what they've not yet been convinced by, which is defense counsel. This was a hard-fought case, and I'm not being critical of the DA, but I've done this for a long time, and I believe in our system of justice. People say it's not perfect, but it's the best that the world has. And this, to me, is hallowed ground in a courthouse named after someone who was a friend who I deeply respected. And I want the prosecutor to get the facts in the best way we can at this point in the case, which is through Your Honor.
Weinberg then makes what I think is one of the most striking arguments of the day.
order a hearing, Judge. Don't make Ms. Reed be the first person in the history of the Commonwealth to face re-prosecution for murder by the same prosecutor's office that tried her once and failed to persuade the jury she was guilty. They've not given a single case where facts like this have been ignored. Not a single precedent have they raised. Nationwide, state courts, murder cases, 50 states, federal, where there's been this kind of demonstration that we were silent, we shouldn't be, but she was acquitted.
That is a powerful statement. Don't let Karen Reed be the first person in the history of the Commonwealth to face re-prosecution for murder. We listened to Weinberg masterfully explain the importance of double jeopardy and the history of why it's so important to the justice system. Following that up with the argument that you don't want this to be the first case where it happens, that's powerful. Imagine being a judge with your name attached to the first case of double jeopardy. It's enough to make anyone stop and think. Weinberg finishes his argument strong.
I'm convinced, perhaps, through many years of doing this, that acquittals count. And if she was acquitted, nobody wants her re-prosecuted when it counts to which she's been acquitted. And form's important, procedure's important, but what's more important is substance. What's more important is to find out whether that jury, in fact, voted to acquit and it was a final vote. And then I hope there's no dispute. I hope Mr. Lally will stand up in front of you and join me in asking that those two charges not be prosecuted.
The argument that he makes is so important. This isn't about who did something wrong or should have done something different. This isn't about the defense versus the prosecution. This isn't about anything other than justice and the justice system. And no matter what, every single one of them, the defense attorneys, the prosecutors, and the judge, every single one of them should all want the same thing based on that common priority and goal. The way that he presents his argument with logic and respect for the law and the attitude of a common goal of justice, it's why I think he was the perfect attorney to present this case to the judge. But do you think that the district attorney's office would walk away from those indictments if the jury told them that that was their decision? Or do you think Lally would ignore the substance over form argument? I have my thoughts on that, but I guess we'll have to see. The next part of Weinberg's argument is regarding manifest necessity. So here's why this is important. The manifest necessity refers to a circumstance in a trial that is unforeseeable and overwhelming, making it impossible to reach a fair result, which makes it necessary to declare a mistrial. So if there is manifest necessity, the defendant can be retried without violating double jeopardy. So in this case, a mistrial was declared because the jury could not reach unanimous verdicts on all three charges. Now, to force the jury to continue deliberating would make it impossible to have a fair result, since the only way to do so would be for jurors to compromise what they are convinced of in order to agree so that they can be done. Imagine if a judge told the jury, you aren't allowed to go home and continue on with your lives until you all agree. So in that situation, the best way to guarantee a fair result would be declare a mistrial, in which case another trial may be pursued if the prosecutors decide to move forward. Now, in some cases, they may realize that they don't have enough evidence to convict and they decide not to move forward with another trial. But double jeopardy does not apply because they are allowed to do so if they choose. Weinberg points out that there are explicit guidelines set out by the Supreme Judicial Court about this, that they have to look to see where there are options, or if there are options, if the court had no other choice but to declare a mistrial. If the judge read the note as saying that the jurors were at an impasse on all three indictments, that would have rationalized the mistrial. But they're saying that they were only hung up on the second charge and the lesser includeds. So now it becomes an issue of who bears that burden. Had the note been clear that there was only an impasse on the charges related to the second count, the judge would have had a much clearer line of where to go from there. But since the note didn't specify that they had reached unanimous decisions on 2 of the 3 counts, the judge and attorneys and probably pretty much everyone watching just assumed that it was understood or had already been clarified that it was all 3 counts. But who carries the burden for that? Is it fair for a defendant to have to be tried again because there was confusion about the juror's note? Weinberg says that the Supreme Judicial Court has issued multiple opinions on the burden of proof, double jeopardy, and manifest necessity. He lists off examples and says in each one, the burden proving manifest necessity lies with the prosecution. Weinberg brings up Rule 27B. He says that the judge was not advised of this. That burden was on Lally. But 27B states that a judge may declare mistrial as to any charges upon which the jury cannot agree upon a verdict, provided, however, that the judge may first require the jury to return verdicts on those charges upon which the jury can agree, and direct that such verdicts be received and recorded. He says the advisory board is even more explicit. This rule also provides that the court may declare a mistrial in cases where the jury is unable to reach a verdict. However, it must first receive and record the verdicts which the jury can agree on.
That rule, had it been brought to the court's view, provided a viable option to a declaration of a mistrial. Would have justified the courts, it would have required the court, as well as justified, to ask the jury whether or not it was an impasse on all counts, or rather than just one. So the Supreme Court not only puts the heavy burden on the prosecutor, but provides a set of guidelines which were established back by the Stewart case and repeated most recently by the Taylor case. And they even call them 2 principles guiding our review of manifest necessity. One is counsel must have been given, and the word must implies it as a mandatory, as an imperative. Quote, counsel must have been given full opportunity to be heard, and I'll address that second. And quote, the trial judge must have given careful consideration to alternatives to a mistrial. These are the legal imperatives, and we contend respectfully, for a variety of reasons, that neither of those 2 guiding principles were met by the evidence of what occurred on July 1, where we have the chronology of, Your Honor, taking argument from counsel regarding the warning note, and the prosecutor didn't want a TUI instruction. Defense counsel did. Your Honor elected to give a TUI instruction. And 4 hours later, the jury sent a second note. And unfortunately, there was no convening of counsel and no request for counsel's position, no opportunity for Mr. Yannetti and Jackson to speak to Ms. Reed. After all, it's her rights, not just theirs. And there was this lack of consideration, careful consideration of Rule 27B, which the prosecutor failed to bring to the court's attention.
So Weinberg points out that the defense attorneys weren't given a chance to discuss the mistrial with Karen Reed. After all, it's her rights, not theirs. And he points out that Lally failed to provide the Rule 27 instructions on providing and recording partial verdicts. He ends his argument to the court by saying that the prosecution should join them in asking the court to establish a procedure at the judge's discretion that allows the defense lawyers to supplement the declarations from the juror affidavits, or just cut right to it. Bring the jurors in, because it's the right thing to do. Compelling arguments for sure. But does Lally agree? If it's justice that they're all seeking, will Lally actually do like he said and join with the defense in asking for clarification from the jurors to guarantee that the defendant's rights are protected and the right thing is done? Here's how Lally starts his argument.
Your Honor, the Commonwealth would ask courts that you and it still should have switched the lines. It was not a verdict returned. Counsel had more than adequate opportunity to be heard and object to the declaration of the mistrial in the case, and then mistrial was declared as a manifest necessity.
Well, there goes that. Lally's first words are that he requests for the motion to be denied. Lally argues that Rule 27B doesn't apply here. He argues that Rule 27B is the right of the court to take partial verdicts, which he says the court is definitely entitled to do if that were at any point in time indicated in any of the communications from the jury that they had reached a partial verdict. He says that the rule doesn't involve inquiring about a partial verdict or trying to extract or coerce a partial verdict by polling the jury, who has declared to the court that they are at an impasse. I'll be honest, I knew that Lally wouldn't want to join in with the defense on their argument to get to the truth here. But hearing the tone that Lally immediately comes out with, it's frustrating. There's no concern from him about truth or justice or double jeopardy or making sure that the confusion that was expressed by these jurors is addressed or cleared up. There's no concern for constitutional rights or a search for justice and figuring out where to go from here. He doesn't even pretend to care. It's an immediate no. They didn't tell us that they were confused, so they don't get to be heard now. I spent almost a year listening to the lawyering styles of Lally and the defense attorneys. And there are some things that I've pointed out with the defense that I didn't necessarily agree with or things that I thought were a stretch, same as with any trial that I've covered. But this is different. This isn't just lawyering style. This is a complete disregard for truth. Lally doesn't care. He doesn't care about jurors saying that they unanimously agreed. He doesn't care that they were confused and didn't know what to do or how to go about things. He doesn't care that they could have potentially reached 2 unanimous verdicts. And he doesn't care that Karen Reed may have to face trial again on 2 counts that he already failed to prove to a jury of 12 of her peers one time. Lally doesn't care. And his very first arguments right out of the gate demonstrated that. I recently covered the case of Chad Doerman of Claremont County, Ohio, who shot and killed all 3 of his beautiful boys, 7-year-old Clayton, 4-year-old Hunter, and 3-year-old Chase. When police arrived, Doerman was sitting on his steps, the gun still beside him, with the 3 boys lined up in the yard in front of him while their mother screamed and cried. He was arrested, and he told police that he had been planning this for months. During a pretrial hearing, though, Doerman's attorneys argued to have his confession thrown out because when he was read his Miranda rights, it wasn't read in full. This man is despicable. The details of this case are so brutal and gut-wrenching. I can't make it through coverage without crying. I don't think that Doerman ever deserves to see the light of day again, and anything other than life behind bars would be way too good for him. However, even Doerman, the lowest of the low, has constitutional rights that need to be upheld. The judge ruled to throw out his confession, and I agreed with the decision, not because I think that he deserves it, but because it's the right thing to do. There are times when I really dislike a defendant, times when evidence is overwhelming and I know beyond a reasonable doubt that they're guilty. But even those people have constitutional rights, and even those cases deserve the truth, whatever it may be. It blows my mind that Lally, whose sole job is to seek justice, is so unwilling to even pretend to care about seeking the truth. After all, he represents the Commonwealth of Massachusetts. But he's adamant that he doesn't even want to hear what the jurors have to say. It seems like Lally is trying to twist the 27B rule so that it somehow doesn't apply, which is ironic since Lally's next argument is that the defense is twisting the logic into a pretzel in order to have circumstances of the case fit into the precedent. He says that there is clear and unequivocal precedent on each of those points that goes back decades, if not centuries. He brings up these cases that he says show the clear and unequivocal precedent on each of these. And one that he mentions is a juvenile versus the Commonwealth. Now, in this case, following jury deliberations, the court officers found verdict slips in the deliberation room that said not guilty. Lally says that this case is directly applicable to what has been provided to the court so far, and says that the case law here shows it's not enough to show that the jury may have agreed on some issues at some time. But here's the thing, the case that he's bringing up is different, and I personally don't think it's applicable. That case had 4 verdict slips that were picked up after deliberations, 2 of which reflected entries of not guilty. However, there was no indication as to when the entries were made or in what circumstances, and nothing determined that they reflected a final unanimous conclusion for the jurors. That's not the same thing as we see here. These jurors are saying that they all agreed their final decision was that they were not guilty on counts 1 and 3. So it's not even the same thing. He also brings up the case of Bluford versus Arkansas as an example to support his argument. Now, in that case, there was only one charge with lesser includeds. So there wasn't a count 1 and a count 3 or anything like that. There was only one, plus the lesser includeds. Now, the foreperson in that case said that the jury was unanimous against conviction on certain charges, meaning maybe they all agreed that it wouldn't be the biggest charge that they would convict on, or maybe they all agreed that it wouldn't be the top 2, but they were hung up on some of the other lesser includeds. But the point is, they were sent back to continue deliberating because the law required for them to either convict on one of the charges or acquit on all of them. Because remember, it's all one indictment. This was one charge with lesser includeds. Totally different scenario. They didn't have the option to do a partial verdict because there weren't separate indictments. It's not the same thing. Also, the juror saying that they had agreed on some of the charges on there was also not the final resolution of anything. There was no indication at the conclusion of deliberations that it was still the case that they were unanimous that the defendant was not guilty. So again, this case is different. The jurors in the Karen Reed case are saying that it was the final decision that they were unanimously not guilty on those 2 counts. Lally then says that the jury was given lengthy instructions and stated that at least 9 or 10 times the jury instruction said what a unanimous verdict was and how to come to that unanimous verdict and how to record that unanimous verdict. Now, look, this is true, but again, those same jury instructions specifically said not to return the verdict forms until the jury was unanimous on all 3 counts. But they never made it to the point where they were unanimous on all 3. So his argument is yet another moot point. Lally says that there's nothing special about this case and that there's no special application or procedure that needs to be developed, created, and deployed as it applies to this case or this defendant. Lally continues on, saying that the procedures suggested by the defense are completely inappropriate and in direct contradiction of what the case law states.
I can't imagine whatever the jurors have undergone since July 1st, as far as extraneous influences, whether it's personal, professional, who they talked to, what they talked about, how those things have formulated in their minds. The intense pressure that they felt just looking at the affidavit from the one juror in regard to the comment that the court had allowed with reference to the jurors' information remaining anonymous, at least for the time being. With respect to that is exactly what the case law advises against and governs as far as taking this sort of post hoc weeks or months after a verdict has been returned or not returned, and then asking people to put themselves back in a position and indicate to the court exactly what was going on in that deliberative process. Asking them how they voted or what their vote was is infringing into that deliberative process that is specifically excluded from any sort of point of contention or inquiry by counsel, by the court, at any point in time.
Again, Lally is making an argument that this is an intrusion into the deliberation process, which, not surprisingly, I disagree with. They aren't asking to dig into the deliberation process, only the verdict. That's it. He goes on to say that there is no requirement for the court to poll the jurors or to ask them if they have a vote on whether or not they have a partial vote. Then, never missing an opportunity to insult the defense, he says that their argument is disingenuous when it comes to indicating that those cases only apply to charges with lesser charges that have a multiplicity of different findings that the jury can make. Because, he says, it ignores the fact that the two charges that they are asking to dismiss were what he describes as very simple, either guilty or not guilty, with no lesser included charges. Now, again, I don't know if he's intentionally being ironic, but the fact that he's calling the defense's argument disingenuous when it comes to multiple potential jury findings is wild, since he literally just acknowledged that there are multiple potential options for this case. Sometimes I don't even know if he realizes the irony in his arguments. Yes, there are two boxes to be checked, either guilty or not guilty. But that wasn't the point. The point was that the case law that he cited doesn't apply. And they explained why. The case law that he cited was about a charge, one charge, with lesser includeds. The ones that the defense is arguing about are different. I'm not even an attorney, and I understand that. My frustration with Lally continues to grow. Lally does go on to say that the Commonwealth, nor anyone, wants to retry someone who has been acquitted by a jury of their peers. But he says that's not what happened here. He said there was no verdict returned, and polling the jury is what he calls inappropriate, not permitted, and he says the defense's motion should be denied. Mr. Weinberg is given the final argument, a chance at rebuttal against Lally's arguments. He brings up the cases that Lally cited. The first one is the juvenile versus the Commonwealth, and Weinberg points out the difference in that case being one indictment with the lesser included charges. The second is the Commonwealth versus Roth, which was another one that had one charge with lesser included. And the court prohibited the judge in that case from asking about a partial verdict or the lesser included charges on that one because they were in fear that mentioning the lesser included charges would coerce the jury into compromising on a lesser charge. He points out that neither of those apply here. We aren't dealing with one count vertically with multiple charges. That would be like if we were dealing only with count 2 here, but that's not the case. He explains we are dealing horizontally with 3 separate charges. He also explains that both Juvenile and Bluford dealt with unanimous verdicts the defense claimed occurred before the end of deliberations, which, again, is different. He also says there's no risk of jury coercion by asking if the deadlock refers to one or all of the charges. Weinberg continues to go down the list of all the reasons why none of the cases that Lally mentioned apply here, because none of them are the same situation. Weinberg agrees it's not the lawyer's place to ask about the views of the 12 jurors or inquire into the deliberation process, but he reminds the judge that's not what they're requesting.
Would not be about the deliberative process. I understand Mr. Lally's citation to Moore, the discomfort and the rules that say jurors should not be asked questions by anyone regarding, why did the Commonwealth not persuade you that Ms. Reed was guilty? Or what did you think of this witness's credibility? Or why did you vote a certain way? Or what did the other 11 jurors say? A deliberating jury is not a focus group. It's not a place, for lawyers to ask about the views of 12 jurors, through the interview with one jury. But Your Honor is being asked to do no more than ask them what you would ask if they came out and said we have a verdict, which is, did you unanimously determine as a final determination that Miss Reed is innocent? Counts 1 and 3. Was your decision unanimous? Did any juror dispute it? That's very different than probing the subjective state of mind or probing for what other jurors said that caused somebody to reach that unanimous verdict. If Mr. Lally's concerned there wasn't a final verdict, Your Honor can ask the question, was it a final verdict? Was there ever a deliberation again after you reached that unanimous decision?
Weinberg also addresses Lally's suggestion that the defense attorneys wanting the Tui Rodriguez charge read means that they were wanting the mistrial. He points out that asking for the Tui Rodriguez to be read simply means that you're asking for the instruction to be given for the jurors to go back and continue deliberations with the instruction from the judge to have the minority reassess their positions. The whole point of it is to see if they are able to reach a verdict. He says that's not the same thing as wanting a mistrial. Weinberg then finishes his argument to the court.
We have evidence here that the jury acquitted Ms. Reed. What can be more central to the core values of our criminal justice system than to make a judicial determination with a respected and experienced Superior Court judge, whether that's so or not, and if it's so, stop her re-prosecution? Because that would be a horror to make her convince 24 jurors of her innocence, a second 12, when she's already convinced the first 12.
Weinberg's rebuttal was just as masterful as his opening original argument. He methodically just goes down the list of Lally's arguments and why they don't apply here. And he does it without insults or snark, without hyperbole or dramatics. Just logical, law-based, and reasonable. And persuasive. I was highly impressed, and I can understand why Mr. Weinberg has such a stellar reputation. Judge Canoni says that she will take it under advisement and rule on it at a later date. As of the time of this recording, no ruling has yet been issued. WBZ reporter Christina Rex, who I mentioned in a previous episode, spoke to jurors from the Karen Reed case, also spoke to a juror on the afternoon of this hearing. She said, quote, "Former juror in Karen Reed trial tells me he or she spoke with a couple other jurors today, and that they think it's pretty simple. If the court wants truth on unanimous, final, not guilty votes on 1 and 3, they will reach out to the jury and bring us back in. If they don't, they won't." End quote. It's just that simple, isn't it? If there's one thing I've learned about this case, it's that it's not predictable. So I'll keep you posted on updates as they come. Next week, we're going to discuss the 2 other cases in the area that have been getting some attention as well. One is Sandra Birchmore, which I introduced in a previous episode. And one is Justin Root, whose family filed a wrongful death suit claiming authorities used excessive force after Justin, who suffered from mental health issues, was shot by police more than 31 times in a parking area after a chase. His family says that Justin was unarmed, though DA Michael Morrissey says that he had a BB gun and 2 paintball guns were found in his car. More on that next week. Also, be sure to check out 13th Juror podcast episode released last week, part 1 of the Ashley Benefield story, the Black Swan murder trial. 24-year-old former ballerina Ashley Byers met 54-year-old retired Navy pilot and businessman Doug Benefield in August of 2016. The two were secretly married after only 13 days, which came as a surprise to Doug's teen daughter Eva, who had just lost her mom less than a year before. Together, Doug and Ashley founded the American National Ballet Company, but their fairy tale didn't last. After less than a year, pregnant Ashley walked out on Doug and their new ballet company. The next 3 years consisted of bitter custody battles and allegations of domestic violence and even poisoning. Ashley shot and killed her estranged husband in September of 2020, claiming self-defense. But prosecutors say that the bullet wounds don't match up with self-defense, and they claim that she was willing to just do anything to get full custody of their young daughter. The 2 sides of the story are very different, and the public seems to be pretty split. So check out episode 1 and listen to both sides. Decide what you believe. My name is Brandy Churchwell, creator of 13th Juror Podcast. If you're enjoying it, please leave us a review on Apple Podcasts and Spotify, and share this episode with your friends. For more information, photos, and episode guides, visit our website at 13thjurorpodcast.com.